SJC-12286 in the matter of a juvenile.
Good morning, Ms. Lockhart-Jenks.
Good morning, Your Honors. May it please the Court. My name is Eliza Lockhart-Jenks, and I represent the appellant juvenile. I have briefed 3 issues, and I'll just start right in on the first one, the conflict between the revocation provisions as regards defendants who are out on release under Section 58 and are charged with committing a new crime.
Could you talk a little louder, please?
I apologize, yes. At the outset, these 2 statutes address the same behavior, but they have different standards for revocation and different consequences. And I want to start by addressing the difference in the length of time of the revocation, 60 versus 90 days. I think it's important to note that that difference is not just a 30-day difference. While a 30-day difference on its own is significant, under Section 58, a revocation can only be 60 days. We know that from Pagan. Section 58B, however, explicitly excludes from that the calculus of the 90 days any time that's excludable under Rule 36. So anytime a defendant asks for a continuance, anytime a defendant doesn't request it or doesn't object to a continuance, anytime a defendant files a motion, that time is excludable under that calculus.
Doesn't that tell us at a minimum, as far as legislative history is concerned, that 58B concerned revocations when you had a 58A dangerousness determination?
Yes, it does, Your Honor.
It's really dispositive of the legislative history, just that point that you have excludable delay under Rule 36 included within the 90 days.
Yes, I think that's correct. And 58A contemplates the same exclusion on its 120 days hold. And Your Honor is correct in pointing out that 58A and 58B were originally promulgated to work together. 58B was meant as a revocation for only people who had been charged with specific crimes, who had been found dangerous under a 58A hearing, and then had been released, and then were charged with committing a new crime or a violation of conditions.
So the problem arises when you have Commonwealth versus Dodge talking about no conditions, and the legislature deals with that issue, and then they realize if there's going to be a revocation based on conditions, that you better put that somewhere. So they put it in 58B, and then you've got the 42A domestic violence situation that they figured could also be a revocation. And then you have JJ that allowed a revocation under 87. So they throw 58 into 58B, and now we don't know what to do with it.
Exactly. And so I think it's clear on its face that these 2 statutes are in conflict. And because of that, as Your Honor points out, we have to go to the legislative history. And I think it's clear from the legislative history that that's exactly what happened. In 2006, the legislature amended 58 and 58B at the same time. And in amending 58, they, for the first time, put in this provision that someone could be placed on Section 58 conditions. But there was no revocation provision for those violation of those conditions. So they simply inserted 58 into 58B. But clearly, what they were trying to remedy was exactly the problem that you point out, Justice Lowy. And so now we're left with this tangled mess of these conflicting statutes. And because there's clearly this conflict, because I think the legislative history is clear as to what they were attempting to do, I think that it's also clear that under the rule of lenity, the 60-day revocation provision should control for defendants who are released under Section 58 and then charged with committing a new crime and the Commonwealth attempts to revoke their bail.
Now, it's actually worse than that, isn't it? Because under Section 58, the Superior Court is not included, correct? That's only under Section 57.
Correct.
So Section 58B does not reference any release under Section 57.
Correct.
So if it's a Superior Court violation, it has to be under Section 58.
Correct.
Unless there's a dangerousness hearing?
I believe that a defendant could be released on conditions under 87 or 42A if they are in Superior Court. But But you're correct. If a defendant is released pursuant to Section 57, if they're charged with a new crime, they would have to be revoked under Section 58, not under 58B.
Unless they had been the subject of a dangerousness hearing.
Correct, yes. So I would just end arguing that issue by saying that I think it's clear that the statutory construction supports that the Section 58 revocation condition, or revocation provision control between those two. I am also make the argument, Your Honors, that 58B is unconstitutional as applied to defendants who are on release on conditions pursuant to Sections 58, 87, and 42A. And as you know, we've talked about, when 58B was enacted, it was meant to only apply to defendants who had been released pursuant to 58A, defendants charged with specifically enumerated violent felonies who had been subject to a hearing where they were entitled to cross-examination of witnesses, entitled to present their own witnesses, and entitled to testify in their own defense.
Don't you think, though, and I know this issue wasn't raised in J, but don't you think that when this court talked about the procedural protections when there's been an agreement to pretrial probationary conditions and there's a revocation, that you use the 58B outline, that contemplates the protections that were initially part of the 58A?
If I could just clarify, are you asking specifically when someone's on release under Section 87 because they've agreed to the conditions?
Well, I'm asking a bigger picture question. So JJ uses 58B
Yes.
to adjudicate whether or not there's been whether or not there should be a revocation when you have pretrial probation. All right. So why isn't it that JJ sort of it provides the structure for a revocation under 42A, 58, or 87 that sort of infuses those procedural protections that are required to satisfy procedural and substantive due process?
Well, my answer to that is twofold. First, I would say that Section 87 does not require any hearing to be placed on conditions. It simply requires the agreement of the defendant. And secondly, under Jake J, that judge had been considering, first of all, a 60-day revocation. The question was whether or not the judge could revoke bail, but it was a 60-day revocation. And that juvenile had been explicitly warned of the dangers of violating that condition, which is also something that is missing from Section 58B, is this idea of notice, that the defendant should be placed on notice that if they violate a condition of release, they could have their bail revoked for 90 days or more. So I think that the court in Jake J essentially said, you can use this sort of as a model for revocation because we don't really have any other option. The court specifically asked the legislature for help in maybe promulgating something specific, but essentially I think what the court was saying in Jake J was, yes, the judge has inherent power to revoke. Yes, the way they did it in this case was okay because of the notice, because it was a shorter revocation, because due process was satisfied. But I think that Jake J wasn't contemplating the constitutionality necessarily of 58B with regard to all of these defendants, and so I do think it's a separate issue that hasn't been considered yet.
Is it your view under 58B that if somebody is on pretrial probation with a condition of don't use drugs and gets a dirty urine, that constitutes a violation of a condition of release which would trigger 58B, or must it be a violation of a domestic violence condition?
If it's a Section 87 condition, then I think it would trigger 58B because Section 87 only contemplates all conditions. It was added to Section 58B as part of the Domestic Violence Act, but it doesn't specifically relate to domestic violence itself. So I would think a violation of any condition would trigger 58B. And I would note that the procedural protections, I talked a little bit about the procedural protections in 58A, and I also would note that in Paquette, when the court found that the procedural protections in 58, in the revocation provision of 58 were constitutional. Some of those are also missing from Section 58B. One is, again, that the court noted that there was a specific requirement that the defendant be put on notice of what they could be facing. Secondly, the court noted the permissive language in Section 58, that if a defendant met the standard of revocation, the judge may revoke bail but didn't have to. And in Section 58B, as in Section 58A, the word used is shall revoke bail. In Paquette, the court specifically said that revocation under 58 should only be for a serious charge, and that language is missing in 58B. It simply says if there's probable cause that a federal or state crime has been committed. And I would also note that under 58B, if a defendant is, if probable cause has been found that a defendant has been charged with a new crime or has committed a new crime, that there is actually a presumption of danger then at that point that arises.
The reason for all this, I know you realize this, but the reason for all of this is because 58B didn't put all of that, it wasn't in there because somebody had already had all the procedural due process
Right.
protections and Solano substantive due process protections
Right.
because there'd been a 58A hearing.
Exactly.
So why isn't it that, that we just wouldn't recognize that those Solano protections are part of what has to happen when there's a 42A or Section 87 revocation at a minimum, and perhaps even 58 revocation?
Well, I think that that's one way to look at this case. I would just say that currently that's not what the statutes say. Section 42A requires simply a hearing. Section 87, as I said, requires nothing but the agreement of the defendant, and Section 58 requires a hearing with representation, but does not allow for all of the other protections in 58A. So I think that's one way to interpret the statutes and to say going forward this is what's required, but currently as the structure of the statutes is right now, I don't believe that it's constitutional.
What do you think the legislature intended to do or wanted to do or accomplish?
I think that the legislature wanted to create a provision or a way to revoke bail for defendants who were released and had a violation of conditions, because something like that just didn't exist. And I think that they saw that a revocation provision already existed, and so they sort of threw those numbers in there, and it ended up not really working out too well.
Now, you say you had 3 arguments. We've heard 2.
Yes, Your Honor. As to my third argument, I am also asking the court that juveniles specifically, that their bail revocations be reviewable. And I understand that Commonwealth v. Pagan says that that bail revocations are not reviewable, that they're final. But I would ask the court to read this statute through the lens of Section 119, Chapter 53, and remember that juveniles are different. They're meant to be treated as children in need of aid, encouragement, and guidance. And things change really quickly for juveniles. Juveniles who are held are missing school, they're missing time with their families, they're missing out on a lot more things besides what adults are missing. And the court recognized recently in Brannigan how significant pretrial detention can be on someone's life. And I would argue that that is even more significant for a juvenile. And I would also point out that juveniles, when they're being held, are not earning jail credit because juveniles are not sentenced to a specific amount of time when they're sentenced. So they are just languishing essentially in pretrial detention. They are not receiving treatment. And so to not have that provision where their revocation is reviewable means that they are really just left to wait as their time runs out. And that's, I think, runs counter to the goals of the juvenile court. I think that the juvenile court judges need more discretion in order to fulfill that mandate.
And what is the process for review that you would suggest?
I would suggest that the case come before the judge, the revoking judge, and that it be based on a change in circumstances. I would use the language in 58A as a model, that anytime that there's a change in circumstances or something that was not known at the hearing that changes things, that the hearing can be reopened and re-argued.
But you're not advocating that there be a de novo Superior Court bail review?
No, I'm simply arguing that a judge should be able to reconsider his own decision, his or her own decision, upon a change in circumstances.
Now, right now, can't that be done if there's a showing of manifest injustice?
It is true that a manifest injustice could trigger a revocation, but I think that that's a very high standard. The examples laid out in Pagan are that one of the charges is dismissed or that the defendant is found not guilty of something, or that they are not the person charged with the crime that they are accused of. So I think that's a little different than a defendant or a juvenile losing out on school or being kicked off of a team or losing out on other important experiences. However, I would argue that those could also be manifest injustices. So if the court wanted to expand what a manifest injustice meant, then that would also probably accomplish the goal.
So your alternative is to say that in the context of juveniles, manifest injustice has a broader meaning.
Correct.
Okay, thank you.
Thank you, Your Honors.
Ms. Moriarty?
Good morning, Your Honors. May it please the Court, Marina Moriarty on behalf of the Commonwealth. Your Honors, the Revocation Procedures and General Laws, Chapter 276, Section 58 and 58B are not in irreconcilable conflict with each other. Each statute serves a different purpose, and each statute requires a different showing to revoke a person's bail. Perhaps it would be useful to very briefly review the purposes of the statutes at issue. Section 58, the bail statute, establishes a presumption that a person will be released on their personal recognizance and carefully outlines the factors that a judge may consider when deciding to enter a cash bail. Under Section 58, bail may be revoked if a defendant is charged with the crime during a period of release. The court in Paquette said that this assures compliance with the laws and preserves integrity with the judicial process. Section 58A authorizes pretrial detention of persons charged with serious crimes and found to be a danger to the community. Section 58B is inherently intertwined with Section 58A. It permits the revocation of bail when there is probable cause to believe that the person has committed a crime or violated a condition of probation, and that there are no conditions that would reasonably assure the safety of the community. The Commonwealth asserts that these statutes are not ambiguous, that the court should apply them, the plain language, and therefore that the defendant does not need to be afforded the rule of lenity in this case. The purpose of Section 58 is to enforce compliance with judicial orders. The purpose of Section 58B, the Commonwealth asserts, is to protect public safety.
If I can stop you for a moment, I'm going to go back to the legal term screwy. Case is indicted. It's serious enough to be indicted and brought to Superior Court. Person's placed on bail, commits a crime while on bail. There's no dangerousness hearing under 58A. You agree then that pursuant to this statute, all that person would get is the 60 days?
Yes,
Because Section 57 governs Superior Court, and there's no reference to that in 58A.
that is correct.
Same person commits a lesser crime, and in this case is a juvenile, one that may not even be one that would be brought to Superior Court, commits the same underlying crime, and now is under 58A and gets 90 days plus excludable delay. That's what, as far as I can tell, this statute, according to you, requires.
Well, in order to be revoked under 58B in that case, the Commonwealth would also have to demonstrate, and a judge would have to be satisfied, that there were no conditions that would reasonably assure the safety of the community, or that the defendant would be unlikely to abide by any conditions.
Right, but that same finding would have to be made under 58, too.
No, Your Honor, Section 58 doesn't require a consideration of conditions. Section 58.
Oh, yes, I'm sorry, you're right, okay. I mean, it doesn't,
That's the Commonwealth's contention. What makes the two statutes different is that there's the additional element of the consideration of conditions under 58B. It's a harder standard for the Commonwealth to meet. It's a higher burden. The judge has to make those specific findings.
Is that really true, though? I know it's true as a matter of comparing the statutes, but the judge can simply impose conditions under 58 instead of doing the revocation. And in fact, may do both, because the period of time under 58 is only 60 days, and you don't have the excludable delay under Rule 36. So is it really a difference in the real world when the judge is on the bench?
I think that there's some confusion in the real world, Your Honor, which is why we're here today. I think a judge could impose additional conditions under 58. I think a judge could impose additional conditions under 58B after a hearing. But it's clear that there is an additional standard that the Commonwealth must meet under 58B, which suggests that it would be appropriate for a revocation period to be longer when the defendant has demonstrated that there are no conditions that would make him safe in the community. I think it's also important to note another difference in the two statutes is that Section 58 requires that a person be charged with the crime, whereas Section 58B does not require that a formal charge have been instituted. I think there are several reasons for this. One could be 58B revocations could perhaps be speedier in the process. And again, I think it addresses the Commonwealth's contention that 58B is meant to address public safety issues.
So do you agree with your sister's characterization of what the legislature intended with this sleight of hand here?
There is no legislative history, Your Honor, so it's unclear. What is clear is when the statute was enacted, it was enacted with Section 58A in 1994 in response to this court's decision in Amy. It was amended significantly to include Section 58 in 2006. I don't think this court can discount the fact that that was the an act to address gang violence. And again, it was amended in 2014 to address domestic violence. So I think that what the legislature was intending to do was to give judges broader discretion in revoking bail for persons who have been released, yet commit additional criminal acts, and are unable to abide by the conditions of the court.
You realize when you make the argument that 58 requires a new charge and 58B doesn't, that shows a difference between the two statutes, but it's not helpful to the constitutional argument.
I agree it could cut both ways, Your Honor. However, I think it was intentional that the language was not included in.
I understand it helps you. I understand it helps your argument of there's a difference between the two, but it doesn't help the constitutional argument.
I don't necessarily, actually, I misunderstood your question. I don't necessarily agree. I think that there's still a standard where a judge has to find probable cause to believe. It's the same standard that a magistrate would have had to find in order to issue a complaint. So I don't think that there's any substantive or procedural due process with respect to Section 58B. Section 58B is narrowly tailored. It only addresses those defendants who have been released under the three statutes and who go on to either commit additional criminal acts or violate conditions of their probation. As the court noted in Paquette, the defendant holds the key. He or she has to be reasonably assured or has to understand that being released on bail, whether they're given bail warnings pursuant to Section 58 or bail warnings with respect to Section 58A, that their release is conditional and that they are expected to abide by conditions of the court and the Commonwealth laws.
And do you agree with your sister that the violations of condition that may trigger 58B could include pretrial probation condition of don't use drugs?
Yes, Your Honor. However, I disagree with my sister in that I think the court still retains the discretion that this court found important in Paquette. Although the statute does say that the court shall revoke bail and that there is a presumption, the judge still has discretion to discredit the Commonwealth's evidence or find that there are conditions of release that will assure the safety of the community.
But you had said earlier, wasn't the focus of that inclusion the focus on domestic violence?
In 2014, the DV Act, Sections 42A and 87 were added to 58B.
But they produced a law that goes well beyond that in terms of violation of conditions.
Yes, Your Honor, and significantly 58 was amended in many ways. However, the revocation provision of 58 was not amended in 2014. again, to address the procedural due process issues, here, there is no question that the defendant is entitled to a hearing, whether or not although the fact that he is not the statute doesn't contemplate an attorney, I don't think any court in the Commonwealth would hold a 58B hearing without the defendant being represented. He certainly has a Sixth Amendment right to counsel. There's bail warnings that are given pursuant to Section 58 and 58A that nearly every defendant in this Commonwealth receives. So I think the notice argument is weaker. And finally, I would point to this court's decision in Jake J., which impliedly found 58B satisfied procedural due process.
I was confused by one thing you just said about the conditions, because the additional conditions are only an element of 58A, right? So in order to find you dangerous on 58, no other conditions can, preserve safety, whatever the language is, right?
There's language in 58B that addresses conditions.
Okay, so if you were you went out on bail on 58, and then they revoke you on 58B, you still have that no other conditions language? I'm confused.
Yes,
by that.
yes.
Okay.
So the Commonwealth would have to demonstrate probable cause to believe that the person committed a crime,
Right.
and that there are no conditions that would safely assure the
Okay, so that
the
carries
community.
over into 58B. I got you. Okay.
And what do you say about your sister's view that we should be more generous to juveniles with regard to change in circumstances?
Your Honor, I urge the court not to reach the issue. It far exceeds the scope of the reported question in this case. Judge Lowy decided that the lower court judge in a single justice session did not abuse his discretion. That was the end of the discussion with respect to the underlying case. Moreover, it was not raised below. The issue of the bail revocation and revisiting the juvenile's bail was addressed under the familiar Pagan standards, and there was no suggestion, and certainly there's no record in this case that the juvenile urged the juvenile court to expand the scope of Pagan with respect to juveniles. Most importantly, I would suggest that we are talking about juvenile courts where these bail revocations are held in the first instance. So a judge revoking bail in juvenile court is fully aware of the nature of juvenile court, the rehabilitative purpose of juvenile court, and so his decision to revoke bail in the first place takes into consideration the arguments that the juvenile is making today. This court has never said that bail statutes should be applied differently with respect to juveniles. In fact, it's just the opposite. Every decision from this court has suggested that the legislature intended that the bail statutes be applied to juveniles and adults similarly.
But your sister makes the point that there's one huge inherent difference, which is that you get credit for time served as an adult. You don't get credit for time served as a juvenile.
That may be the case. However, DYS commitment is also significantly different than commitment to a house of corrections. So from my understanding of juvenile court, Your Honor, there's a wide variety of placements when you are in DYS commitment. And so I would just ask that this court hold off on addressing that one particular issue where it exceeds the scope of the reported question, and there's an insufficient record for it today.
Okay, thank you.
Thank you.